Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case. We breaking it all down. No rush, just pace. Yo, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk. How are you guys doing this evening? So, I wanted to kind of go over the wrongful death petition that Angie Stone's children filed in the Georgia State Court. It has been a couple of months since everything has happened, and it's just very dreadful and sad that nobody still has answers. Usually, in these types of cases, I knew eventually a wrongful death lawsuit was going to be filed. But normally, what happens is you pretty much sue everybody and their mama. I'm talking about the trucking company, and that goes for the semi trailer to the trailer that's attached to the semi. Um, they even filed it against the driver or the company that the driver of the Mercedes, I forgot what that man's name is, but they filed it against that luxury transportation company. So they made sure whoever they hired made sure that they did their due diligence and added all the right defendants in this lawsuit. Now, later on down the line, if it has um, come to a point where they have to non-suit, meaning drop somebody from the lawsuit because they found that they have no part in this particular lawsuit or what happened, then they can definitely non-suit it. But without further ado, let's hop into this petition uh, right quick, y'all. It, like I said, I know it's been hard for a couple of months because I can only imagine what the children could be going through as far as losing their family member and still not having answers like they should. So this was actually filed on September 2nd in Gwinnett. I hope I'm saying that right, county in Georgia. And it is her children, Diamond Stone and Michael D'Angelo Archer, who are the surviving children. And let me see, Michael D'Angelo Archer II as the administrator of the estate of Angela Stone, and then Miss Sheila Hopkins individually. Well, if you don't know who she is, then once I get to reading this petition, you guys will figure out who that is. Um, Here are the defendants: CRST Expedited, doing business as CRST, the Transportation Solutions, Jared Wilkinson, the Daimler Truck North America, and I'm pretty sure that is the how you call it, the maker, the people who make the semi truck. Detroit Diesel Corporation, Lethal Carter. That is the driver. That's his name, Lethal Carter. Joseph L. Robinson, and I believe Joseph L. Robinson is the owner of Executive Elite Transportation and Good to Go Cafe. But we'll confirm all of that um, in the parties tab in just a second. Whew. So, I don't want to put on a trigger warning, but a lot of this stuff I'm assuming is going to bring up some unhealed wounds. So, if you have to log off, hey, I get it. If not, I just want to give you guys a fair warning. So, in the early morning hours of March 1st, 2025, Grammy-nominated R&B singer Angela Laverne Stone, also known as Angie Stone, and a group of her bandmates and family members, including Sheila Hopkins, were traveling through Montgomery County, Alabama, after leaving a performance the night before in Mobile, Alabama. Angie's group was riding in a 2021 Mercedes-Benz Sprinter van owned by defendants Good to Go Cafe LLC and Executive Elite Transportation LLC or Joseph L. Robinson, and driven by defendant Lethal Carter, who had been hired to transport Angie and her group from Atlanta, Georgia, to perform in Mobile and then back to Atlanta. Now, I believe the last update that I provided, it was probably the only update. We noticed that Lethal Carter wasn't really supposed to be driving. He had a lot of blemishes on his record, which would indicate I don't know how you got hired by this company, and more importantly, why you are even driving, but that's neither here nor there. While traveling north on I 65, defendant Carter lost control of the Sprinter van, causing the van to exit the roadway to the left. As defendant Carter attempted to steer the Sprinter van back to the right and onto the interstate, the Sprinter van overturned onto its driver's side and came to a rest in the left lane of I 65 North. The right lane of I 65 North was open and not obstructed by the disabled Sprinter van. Angela Stone and Sheila Hopkins, who were both properly belted in rear facing seats behind the front driver and passenger seats, survived the initial collision without serious injury, as did the other occupants of the Sprinter van. So she survived it. So it wasn't the initial collision that caused the serious injuries. That's number one. I want to point that out. Number two, remember back in the last video, Lethal, all he knows is that he woke up and that was it. He didn't know what happened. He assumed that he may have fell asleep behind the wheel. Now that we have attorneys involved, and I'm pretty sure, and I will go over what's going to happen after this, but now these are the detailed accounts as to what happened. During the next several minutes, all the passengers, including Angie Stone and Sheila Hopkins, attempted to get out of the overturned Sprinter van. During this time, the headlights, taillights, and runner lights on the Sprinter van remained on because they were paying proper attention to the roadway in front of them and not driving too fast for the conditions. Several other motorists traveled northbound on I 65, saw the overturned Sprinter van, and safely drove their vehicles around it in the open right lane. Other motorists paying proper attention to the roadway also saw the overturned Sprinter van, pulled over to the right shoulder of the interstate, and put their four-way flashers on. With the help of Good Samaritans, five of the nine occupants were able to exit the Sprinter van. Around 4:25 a.m., a large CRST tractor trailer driven by defendant Jared Wilkinson was proceeding in the left fast lane of travel on I 65 North. Defendant Wilkinson was on his way to deliver a load of sugar to Forest Park, Georgia. The CRST tractor Wilkinson was driving was a 2021 Freightliner equipped with Detroit Assurance 5.0, a collision mitigation system designed, manufactured, marketed, and sold by the defendants Daimler Truck North America LLC and Detroit Diesel Corporation. The Detroit Assurance 5.0 collision mitigation system is marketed and advertised as a system that will warn tractor trailer drivers of moving and stationary objects in the roadway, particularly particularly break the tractor trailer, and then fully break the tractor trailer if the driver does not respond. So pretty much what they're saying is that the truck would have it's kind of like in these new model cars, I know in my Volkswagen, if I back out and somebody's coming down the alleyway, then my car will automatically brake for me. That's what they're saying, this system. So that explains why Detroit Diesel and the Daimler Truck North American LLC was added to the lawsuit because the mitigation system did not do what it was supposed to do. Because defendant Wilkinson was not paying proper attention to the roadway ahead of him, and because the Detroit Assurance 5.0 collision mitigation system, did not warn Wilkinson of the disabled Sprinter van or automatically brake the CRST tractor trailer, Wilkinson slammed the front of the CRST tractor trailer into the disabled Sprinter van at high speeds without ever applying the brake. Now, I'm wondering if you guys are trying to figure out, well, how do they know all of this information? Please note that before we get to litigation, we go through a pre litigation phase. That means, well, in this case, there's not really much treatment that's going on because Miss Angie Stone was deceased, but you still have to go through the process of getting all of the documents, her medical records, her medical bills, if there were any, funeral record, bills, expenses, so on and so forth, death certificate, all of that. And then what happens is we will draft a demand, and then we will send it to the responsible parties. So the trucking insurance company, Elite Transportation. So those two companies is like, hey, we here's the demand letter. We're demanding to pay X amount of dollars. If they fail to come to a negotiation or a settlement, then a lawsuit is going to be filed. And that is why we are here today with this lawsuit. Oh, this is so sad. At the time of the CRST tractor trailer slammed into the overturned Sprinter van, both Angie Stone and Sheila Hopkins were still inside and trying to get out of the van. The force of the impact was extremely severe. As a result of the collision, Angie Stone was ejected from the pinned underneath the Sprinter van. Angie Stone remained trapped underneath the van, where she consciously suffered until she ultimately succumbed to her fatal injuries she sustained in the collision and passed away. The claims asserted by plaintiffs arise out of the events described above. Now, I know most of this story came from Sheila Hopkins because she was there. She was still in the van with Angie, so she would know what happened at that time. There was a lot of speculation, and I mean, everybody was on point. Like that, when the Sprinter van tilted over or flipped over, that's not when Angie Stone, it's like, how did she get from the van to under the van or outside? There was a lot of speculation going on, but this lawsuit sums it up. All right. So the parties, as I stated, was the kids, obviously the 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 individual truck company that would have been the for the semi, as well as the trailer, and then the company that put the mitigated system in the truck to detect when something is stationary and to apply the brakes or to alert the driver. So those are all the parties that are currently being sued. um huh, I'm just kind of going through this to kind of go over. All right, so here are the operative facts. So during the early morning hours of March 1st, 2025, Angie, Sheila Hawkins, and a group of her bandmates were driving through Montgomery County, Alabama, traveling back to Atlanta, Georgia. As we stated before, Angie and Sheila was properly seated. They had their seatbelts on in that 2021 Mercedes-Benz Sprinter van. That was owned by the Elite, Executive Elite, and Defendants Good to Go, and Lethal Carter was the driver. He was hired by that. Now I'm telling y'all right now, so the way that this is going to be, because right now it was just served on the second, and I see that there's a lot of summons, so they have to alert the defendants of this lawsuit. After everybody is alerted, then what will happen is they will get out what's called a request for discovery. So the plaintiff's attorney will send discovery requests to the defendants, all of them. So that would be interrogatories, requests for production, as well as admissions. The key part is one, the interrogatories, because there's a list of questions that each defendant will have to answer. The most important person would be, I would say, Lethal Carter, because he was the one driving. But then also, why didn't that truck alert the truck driver of the stationary object, which was the Sprinter van? Why it did not alert and apply the brakes? So Those two right there is going to be very, very important when it comes to interrogatories, those questions being answered, because when they get to depositions, it's really going to be on. They're going to pound them regarding the nature of this case. In addition to that, it's going to be a request for production, what we call that. Now, I would say for the trucking company, that's going to be something that the plaintiffs are really going to need, because we need to figure out, why didn't that truck alert the driver? Why didn't that truck um, apply the brakes? When was the last time it was maintenance? Have you ever had any faulty problems? Has the driver ever uh alerted the company that something was wrong with it? A whole bunch of, so it's going to be a list of questions and a list of documents that they are going to have to produce to the plaintiffs. And then vice versa. The defendants, all of them, the trucking company, Letha Carter, Elite Transportation, they're going to come up with their discovery request, a list of questions and a list of documents that they want, and they're going to submit that to the plaintiff. Once all of this is in, so once all the questions have been answered, all the admissions have been either admitted or denied, and all of the documents have been gathered and have been reviewed by both parties, then they are going to schedule for depositions. Depositions is going to be the key here, because this gives the opportunity for them to go to either the plaintiff's office or the defendant's attorney's office, and or via Zoom, because we do Zoom now too. We don't even have to go to no offices. And that would give the opportunity for the attorneys on each side to ask their opposite parties questions. And that is where a lot of stuff comes out. Things that wasn't mentioned in a lawsuit might come out. Things that were not mentioned in the discovery, the written discovery, will come out. So I'm very curious to see what the depositions are going to look like. All right. So we know that and when I say he, the driver of the Mercedes, he attempted to steer the van back to the right. So I'm thinking maybe this man fell asleep. He woke up and realized he was drifting off and tried to correct and overcorrect it, causing the Sprinter van to overturn. Let me see. The right lane was open. So this we've read this. The most important thing we need to take away is that Angie Stone and Sheila Hopkins were alive and conscious following the Sprinter van overturning, and they were trying to get out of the van. But now this goes back to that lady. That lady wasn't lying. Remember what they was talking about? This lady said that she stopped and she tried to help them, and this 18-wheeler breezed past her. And yeah, that lady wasn't telling a story. She was telling the truth. And if in order for that van to look the way it did, and the injuries and resulting in this, the unaliving, it had to be going, what, about between 70 and 80 miles per hour. That impact was severe. That impact was very severe. Let me see. Five of the nine occupants were able to exit the vehicle with the help of Good Samaritans who actually pulled over. Um, I want to see what's going on. So let's see about Mr. Wilkerson, the driver. So it said he was driving an owned, operated, maintained, repaired, and controlled by defendant CRST and driven pursuant to their dot number and motor carrier authority. Now, defendant Wilkerson was listening to music while driving using a pair of headphones. So he was using a pair of headphones. Of course, he would not have heard the warning. However, it still doesn't negate the fact that it was supposed to automatically apply the brakes. Okay. The weather was clear. That did not have anything to do with the subject collision. Let's see the roadway. was straight and flat, such that the overturned van was visible to other motorists. Because, like they said earlier on in the petition, that people were slowing down, people were getting in their far right lane or in the right lane and going slow. So this man wasn't paying attention. He was jamming out to music. This is ridiculous. This talks about how the Freightliner had the mitigation system that was designed, tested, manufactured, distributed, promoted, advertised, and marketed by the defenders Daimler and Detroit Diesel. So this thing failed to respond. And let's see what it does. So it is supposed to use radar and camera technology to monitor the road, including stationary objects in the road like disabled vehicles, and provide audio and visual warning to the driver. And if the driver does not respond, automatically apply partial or full braking to avoid or mitigate potential collisions. Prior to striking the disabled Sprinter van, the Detroit Assurance 5.0 collision mitigation system did not issue an audible or visual warning to defendant Wilkerson and did not apply any or automatic partial or full braking to avoid or mitigate the collision. Because Derek Wilkinson was not paying proper attention to the roadway ahead of him, he slammed the front of the CRST tractor trailer into the disabled Sprinter van at a highway speeds without ever applying the brake. Defendant Wilkinson was not paying proper attention to the roadway when he negligently, crashed the large CRST tractor trailer into the disabled Sprinter van. The brakes on the CRST tractor trailer were never applied by Wilkinson or the Detroit Assurance 5.0 collision mitigation system, and the tractor trailer was going nearly 70 miles per hour upon impact with the Sprinter van. I know I handle truck and car wrecks every day, so I automatically knew that. The impact was extremely severe. Here's my thing, and if I hope that they use one of the they can recreate the scene, but from what I am thinking that happened, because mind you guys, the van was kind of like in the median in the grassy area. So I'm thinking while he's traveling with his headphones on 70 miles per hour and he's jamming out, he doesn't realize that there are people slowing down ahead. By the time he realized that there was like brake lights and people, he probably swerved, causing him to go in the direction of the Sprinter van, and that's what happened. That's the only thing that I can think of. And that is probably the reason. Now, why the brake system, that mitigation system didn't detect that, that's still something that is very, very crucial in this particular case, because if you have a system, now we already know that sometimes technology can be a little woozy, but it still doesn't negate the fact that this system should have worked. Now, I don't know if it's because it was in the wee hours in the morning and it doesn't work well, when it's pitch black. I don't even know what the highway is around that time in that area. Are there traffic, no, not traffic lights, but the lights along the highway, are those there? So there's so many things that has to come out, and they probably already have this information. It's just not available in the petition, but um that's what I'm thinking. uh that's the type of questions that I will ask. Oh my gosh. So as a result, Angie Stone was ejected from the Sprinter van and pinned underneath the van. She remained trapped underneath the van where she consciously suffered until she succumbed to her fatal injuries she sustained as a result of the Sprinter van being struck by the CRST tractor trailer. Miss Hopkins remained trapped inside the Sprinter van as it was catapulted into the air. Oh my gosh, and slammed back down onto the roadway. Miss Hopkins miraculously survived the collision but suffered injuries for which she was immediately treated at Baptist South Hospital in Montgomery, Alabama, and for which she is being treated. Yeah, if it happened in March and based off of getting hit by an 18 wheeler I have experience, you're not going to heal in a couple of months. So as she is still being treating, she's racking up her medical bills on this case. CRST selected listed specifications for owned, maintained, repaired, and control of the. So pretty much what they're saying is that CRST knew that defendant Wilkerson was driving this trailer or a semi. They're responsible. They have to train him, they have to screen him, they have to make sure that he's qualified, so on and so forth. So one of the things I know they're going to ask for is a copy of their training records. Like, how often was defendant Wilkerson trained? Does he have any type of disciplinary actions? Have he ever been written up? Has he been in any other collisions? So on and so forth. All of this is going to be asked by the plaintiff's counsel. Oh man. He was doing this as the scope of his employment. Oh man, was follow. So this is what they're getting him on: following too closely, distracted, fatigue, not paying proper attention to the roadway, and driving too fast for conditions at or around the time of the subject collision. So this is what he getting sued for. The mitigation system did not warn him of the overturned Sprinter van. It was negligent. So this is a negligence claim. Everybody, all the defendants listed here was negligent. They had a duty to ensure the safety of not just the people that was on that Sprinter van, but all of the people that were on the roadways that morning. So we have Oh, okay. So this is the liability of defendant. So this is kind of even though this is not a criminal case, just think of it as the charge against the defendant. So Jared Wilkinson, who was the driver of the truck, he's negligent. Let's see. This is sad. CRST is negligent for hiring and not properly training Mr. Wilkinson. Strict products liability and negligence as to defendant Daimler. So this is in regards to the 2021 Freightliner, making sure that they, maintain the maintenance on this particular tractor or semi. I always want to call it a tractor trailer, a semi. And then also making sure that it is equipped with system that can avoid crashes. So that's why they included in there. Oh man, oh look at this. And then they're talking about Daimler because they're in Detroit. They are responsible for the active brake assist. So this is what it is. So the ABA 5 is promoted and advertised by Daimler as providing audio and visual warnings as well as full braking on moving and stationary vehicles. So let's see what it says. So active brake assist ABA 5 mitigates potential collisions by calculating truck speeds and distance to other vehicles. This determines if a warning or braking action is needed. Full braking on a moving pedestrian can detect a person who is about to walk into the truck's path. It uses audio and visual warnings with the simultaneously partial braking first, followed by full braking if the driver does not react. Then we have full braking on moving and stationary vehicles, can identify moving or stationary vehicles in the truck's path. When the system detects a potential obstacle, it issues audio and visual warnings. Depending on the situation, partial and full braking may activate as well. Ooh, this is a big case. This is a very, very big case. So they're just kind of going in and showing how they were negligent ensuring that that system worked properly. How often is it maintenance? So we're going to figure out all of that. Like I said before, if he wasn't paying attention and there were cars that was already breaking, why didn't the system work? Was it because it couldn't see, because it was too dark? Like there are just so many factors, so many factors. Failure to warn. Well, it didn't, the system didn't warn him because even though he had his headphones on, it could have partially break. And I'm just summarizing because we don't have to read all this. It's 41 pages. Um, so negligence on the driver, negligence on the driving company, negligence on the companies that advertised and installed that ABS 4 or 5, whatever that thing is, Detroit Assurance 5.0 mitigation system. They're negligent. So they're negligent in not maintaining maintaining it and ensuring that it works properly. It's also a product's liability because it's faulty. It did not work when it was supposed to. Boy, when I tell you this is a $1 million claim. This is a $1 million claim. They're going to get millions off of this. And there's no amount of money that will actually take the pain that the family is feeling, but at least it holds the companies and the individuals responsible. It holds them accountable. But I do hope that they get over $5 million. I hope it's not no chump change. Like I was able to be a part of a case that we settled for $3.4 million when a drunk driver slammed into another vehicle and that vehicle landed on top of a city worker. And we just got $3.4 million for that. So this particular case, it better be over 10 million. I can see that happening. And each of those individuals are going to have to come up with something. The companies, not just for the negligence part, but also for the product's liability part. Mhm. All right, so let's go. Failure to warn. So we got negligence, failure to warn, and products liability. Ah, Mr. Letha Carter. Letha Carter, Letha Carter. Mm-mm-mm. He wasn't paying attention. According to him, he was asleep. Remember, y'all? He failed to operate the Sprinter van in a safe and prudent manner. All right, defendants. So that's the Elite Trucking Company. And then they're asking for attorney fees and litigation expenses, damages. Let me see. I don't think they put a number. Yeah, they didn't put a number on it, but they are asking for pre-impact and post-impact shock, fright, and terror that Angie Stone experienced prior and during the subject collisions. They ask for all components of mental and physical pain and suffering and general damages endured by Angie Stone, all emergency transportation expenses, medical bills, funeral and burial expenses for Angie Stone, punitive damage to punish, penalize, and or deter defendants, attorney's fees and litigation expenses, and all other damages that the court sees fit. For Sheila Hopkins, they're also doing the same thing. Pre-impact for pre and post impact for the shock, fright, and terror that she experienced prior and during the collisions. For mental and pain, physical pain and suffering, general damages. Asking for all of her past and future medical bills to be paid for. Punitive damages, attorney fees, and litigation, and whatever damages the court sees fit. I was gonna say something. But yes, yes. This is truly sad. And that's what I was gonna say. And the defendant, CRST, They just had a federal lawsuit against them for not paying wages, I believe. So right now, it's just not looking good for their company. I'm pretty sure their company is going downhill. So just to be involved in another, and this is not just a tiny lawsuit. Like, you hired an individual that obviously wasn't trained well, because how do you use headphones? You can't hear nothing. You can't hear sirens. You can't hear anything. You can't hear a BOMB go off if you have your headphones on. You can't hear horns honking at you. You can't hear anything. So this is going to be a very, very interesting case. So as of right now, they are trying to serve all of the defendants. Once they are served, the defendants will have between 14 to 30 days to file their answers in court. Once the answers are filed, then that's when discovery starts, and that's when they issue out interrogatories, admissions, and requests for productions, and they exchange. So plaintiff will get it from defendant, and defendant will get that from plaintiffs. Once they have answered all of the questions, admitted and denied to admissions, gathered all the documents that they were requested, they are going to review those, and then they are going to schedule for depositions. It is the depositions that we really, really want to pay attention to. Now, they're not going to sit there. We're not going to be able to see the depositions. Maybe I can get my hands on a deposition transcript once that happens. But the main deposition I want to look at is Lethal Carter. Not even just his deposition, also the discovery. I want to see how he answered the questions, like what really happened, because this what I'm looking at on here is totally different from what was stated when it happened. He said he didn't know what happened. He was asleep or fell asleep behind the wheel. Now we know that, okay, you more than likely probably did fall asleep, but you overcorrected. You tried to undo what you did, and it was too late. This is a sad one. This is a sad one. But I am glad that her children are trying to hold these individuals and companies accountable for their mother's unaliving, untimely unaliving. But y'all let me know what y'all think about this. This is sad, but it's something that needs to be done because there are still questions that are unanswered, and I hope that these children get their answers during this lawsuit. But y'all let me know what y'all think in the comments below. Don't forget to like, share, and subscribe. Until then, I'm out. Bye.